property and copyright. So I'll hand over to our two speakers.
I think I'm starting. So thanks for coming. I would like this to be more informal than formal. I don't want to sit here and sort of lecture people. I think Brigit probably feels the same. So Brigit and I work pretty closely together. The way that it works is that I deal with what we call front-end IP work. So, you know, that's drafting your contracts or, you know, generally setting up your portfolio for protection. And then when something goes wrong, that's when Brigit steps in to help out. We've also got a team of lawyers who help us, and they're sitting here on the couch. So we've got Sophie, Glover, Alex Shaw, and Charlotte, whose surname I don't remember because she just started. Hey, there you are. So the way that it works in terms of team structure generally is that we will have the girls who will kind of work with our clients across the whole gamut of issues. So they'll help with the front end, and they'll also get involved in initial back end work where things start to go a little bit awry. If things get very litigious, we then generally have to go out to a barrister, but you know, this is sort of the doom and gloom side, which I'll leave to Brigit. So I think the purpose of this really is to sort of talk a little bit about what it is that you would be thinking about from a protection perspective, what it is that you're doing in your businesses anyway. So whether or not your business is actually around IP creation and protection and then enforcement, and what elements of that are actually able to be registered formally or not. And then from there, we'll talk about, okay, so you've got a level of protection, or you've got assets in terms of intellectual property. How do you enforce that if someone is ripping you off or using your brand or taking your IP if it's a patent or if it's, you know, copyright? What do you do in those circumstances? And then what we're going to do is sort of open it up for questions at the end. I've got a little timer here because I've been told that I need to stick to a certain time limit. So if I'm looking down, it's because of that. So as I said, so who is creating, or, you know, what are you creating in terms of intellectual property? And the things to think about in that regard is, you know, are you creating IP as a company, as an individual? Do you have employees working for you who are doing that work? That's going to impact how you go about protecting your assets, and we'll get to that in a little bit more detail. You know, what types of IP are actually worth protecting? Again, is it formal? Is it not? Are there registrations that you can actually, you know, apply for and then enforce? And we'll talk a bit more detail on that. And then in terms of the actual, you know, creation of IP or content, what is it that you're creating? So some of the things that we think about in that regard, or, you know, in relation to your business itself, are you a brand? Are you creating brands? Are you a business who creates content? Do you write content? Are you a content creator individually? Do you freelance? Or are you an inventor or product developer? You know, that includes, you know, creating products for SaaS, or, you know, you employ developers in your business who, you know, help you develop those sort of programs that you then on-sell to clients. The other one that comes up quite a bit is design work and design protection. So are you a designer? Do you want design protection? How does that work as well? So the way that we go about doing our work is that you as a client will come to us with a particular question around, say, you know, I have a brand, I'm starting a business, or, you know, I already have a business and this is what I do. And then we have a conversation about, okay, well, how far along that road are you in terms of your business, and what is it that you're creating, and can we actually do anything about it? And the way that we structure that is, okay, you know, trademarks, copyright, design rights, patents, trade secrets, these are generally the things that you are able to protect formally. And so the way that I generally look at this is I start with trademarks because that's sort of the umbrella in terms of your business. That's a brand or a subset of brands within your business, and it's actually very easy to manage a trademark portfolio in comparison to some of the other aspects of IP creation and protection. Trademarks, generally, you know, that's words, logos, it could be a phrase, it could be a smell, although we don't really do that. I don't think we've ever done that, have we? But people do it. And then the way that that's actually managed or protected is a formal process with IP Australia. We do an actual application, and there's a process involved with that. It takes around 7.5 months, and then you can also do that internationally. And your protection is formalized. It's on a register. It's part of a portfolio of assets that your business will have, and that protection lasts for 10 years, and then you can renew that protection on an ongoing basis. The benefit of that is that you can then enforce that right if someone actually, you know, tries to steal your brand or portfolio of brands. Now, the example that I usually give with this to clients is the easiest way to look at it is that, you know, if you take McDonald's, for instance, you know, their brand is McDonald's, so they have a trademark for that, and they protect that, but then they also have their individual brands underneath that, like the Big Mac, et cetera, and they also have protections for those individual items within their brand portfolio, because some businesses have a number of different products that they, you know, go out and sell and push, and they want to make sure that they can enforce that against other people trying to rip them off, or, you know, trade off that name and try and lead people into thinking that maybe they're somehow related, et cetera, so they would want to protect all of that. That's not necessarily applicable for everyone, but that's kind of a way to think about branding and trademark protection in a general way. The things to think about generally with trademark protection is that when you are actually going to try and apply for that to get that protection, because it's a formal process with IP Australia, the things that they look at are, you know, is what you're applying for descriptive of your services? Is it, you know, simply describing what it is that you're doing, in which case they'll likely knock it back, because the view is that you can't have the monopoly on one particular description of a product, because it will mean that you can exclude other people from actually using those terms to describe their products, which is unfair in the market. And the other thing they also look at is just similarity with other brands that already exist. And there are a few things that we can do to help you guys to overcome any of those sorts of issues. But, you know, for the purposes of tonight, it's probably not worth going into that level of detail. So that's trademarks very generally and how that operates, and that makes up one element of, you know, a brand portfolio or IP protections within a business. The next thing that is probably the most common question that people generally ask about how do I protect this is copyright. Now, this is slightly different because unlike a trademark situation in Australia anyway, there's no formal registration process for this. So copyright, generally speaking, you know, this is the form or the way an idea or information is expressed, and it's not the idea itself. So that then is automatically protected under the current regime of copyright in Australia. This is different overseas. Some jurisdictions do allow for protections, but for the purposes of, you know, this situation, we don't have to really think about that at this stage. In terms of the level of protection and timing that you get, it's generally 70 years after the death of the creator or author of that actual copyright. So if you create something or write something, you get automatic protection, and then if you drop dead tomorrow, you have that protection maintained for another 70 years. So that's comforting, I guess. A few things to think about generally with copyright is, you know, it needs to be original or a physical expression, not the idea, because often what happens is that people will come to us and say, oh, how do I protect my idea? And, you know, the idea itself isn't necessarily something that can be protected unless it's like, you know, your idea is a brand name, or it's a, you know, a piece of writing that you've come up with, or it's a television show that you've tried to sell or something like that. The content itself is what is able to be protected, but the notion of it is not. So, you know, a good example of this really is just, you know, writing, art, music, computer programs. The other thing that sort of fits in with this that is worth keeping in mind is the notion of moral rights, which is essentially an individual who creates a work has ongoing moral rights, which means they must be attributed generally if someone uses that copyrighted piece of material, you know, somewhere else. So, you know, that's something also worth thinking about, especially in the context of, you know, if you are assigning your rights in something that you've created, there are other elements to that. It's not necessarily just the be all and end all that you hand it over or someone enters into agreement with you. There may be attribution rights that are ongoing. Design rights, you know, are there any designers here actually? Does anyone do, yeah. What type of design do you guys? Right, how about you? Right, so the design registration process, it can be lengthy and costly, and it really does relate to, you know, pure designs in terms of like shape, pattern, configurations and all of that. And in terms of registrations, it's slightly less than, say, a patent or a trademark. It's around 5 years and can be renewed for another 5 years. But in terms of, you know, we get clients who come to us who are maybe fashion designers and all that sort of stuff who want to register designs. But the fact of the matter is like commercially, if you're someone who designs dresses, for instance, the time and money it would take to actually register the pattern and what's involved in terms of how they assess, you know, whether or not that's something worth registering is probably not worth it if you're, you know, every season designing a different range of products or different clothes or bags or whatever. It's just probably not something that is commercially viable for the business to undertake. So, you know, often it's prohibitive as something that can actually be utilized to protect what it is that you're creating. Patents, we tend to, yeah, go for it. If you're can you, yeah, is that actually on? If you involve lawyers, do you generally involve lawyers? You do? Okay, I consider that to be kind of pricey. I'm saying it on the basis that it's not like a $200 thing or something like that, right? Sorry, yeah. No. Well, good for you that's that's cheap. I should probably get into your line of business. So the one that we also get a lot of inquiry about is patents. And the regime has changed slightly recently, but I'm not going to go into that because it's not really worth it. But generally speaking, you now have essentially two options: a standard patent or an innovation patent. Standard patents around 20 years, innovation patents 8 years. And again, you know, the things to think about with this are around, you know, is it inventive and innovative or useful? And you and I were talking about this before. It's got to be something that is an inventive idea or an inventive aspect of something that exists that can be applied to something that hasn't already been applied to today. The issue with patents generally from a commercial perspective are the moment that you go to market with something that you want to patent, you lose your rights to actually patent it.
Worst.
Yeah, then just turn that off. Yeah, so
Sorry.
So in that regard, if you do have something that is really innovative, inventive, this is annoying. Excellent. Don't tell anyone is kind of the initial response to that until, we know what we're doing with it, or, has it got legs? And, that sort of process can be relatively quick and cheap. That's a consult with a patent attorney that, a couple $100 to see whether or not there's something there worth getting registered. And if it is, you still have the right. But if you do go to market with it and then think retrospectively, okay, this is something that is probably going to be really big for us and we should protect it, then unfortunately there's not much that can be done from that perspective. So again, the process for registration in Australia is IP Australia. It can be costly. But legitimately costly as opposed to varying definitions. So that is an expensive process. But again, something that is actually worth protecting like that can lead to a huge amount of revenue for a business. Yeah. Well, it depends. Like patents can be applied to a number of different things. Yeah. Internationally. Well, Alex knows sort of the ins and outs of the process. It depends. Yeah. But from a practical perspective, how would you, if you can still base it here and then, yeah.
I think the issue is that once you've patented something in Australia, it loses novelty and the ability to be patented in other countries around the world. So you'd be able to protect your patent only in Australia, but you'd be able to, by registering that patent, you'd be preventing other people from registering a similar patent anywhere else in the world. Because one of the requirements of patentability is novelty, in other words, that it doesn't form part of the state of the art or the current knowledge base, and they look at that throughout the world, not just in Australia.
The one thing that is most common with front-end protection work is the idea of trade secrets, which is kind of referred to in a number of different ways. Ideas is one of them. Another way that you could think about it is the sort of general look and feel of something within your business, a methodology, for instance, of how you go about doing things. Or, a lot of consulting businesses, for instance, have, particular methodologies or systems that they use when they go in to a company to assess, aspects of, their performance, for instance, and they've come up with the methodology and they use certain tools that they've developed, et cetera, et cetera. And realistically, all of that falls into the notion of trade secrets. And unfortunately, when it comes to that, a lot of that's going to be dealt with internal contracts that you might enter into, either with your employees or if you're dealing with external people who you are going to see to provide them with certain knowledge that you guys have developed in, such as consulting businesses, is going to be around confidentiality agreements, NDAs, etc. And, the difficulty with that is whether or not your protection around that is actually secured. Because, one school of thought on this is that those sorts of agreements with confidentiality agreements and NDAs, for instance, the money and time that it takes to enforce that, if you need to, is probably not worth the effort. And So, you know, there's one view that it's like, well, you know, why would you enter into it? And then there's another view that it's like, well, if you're going to divulge any level of information about your business that you might be concerned a competitor is going to use or copy, then you should as a protection. But my view on this is that it's more as a deterrent than it is as a protection, because if someone is, you know, signing a document saying, you know, I'm going to sit here and listen to this information, or I'm going to sit here and, you know, watch you do this particular methodology in my business as a consultant, you know, and I'm not going to take it or steal it and then try and reproduce it. It's a mindful sort of agreement that they are definitely not going to try and do that. Whether or not that actually happens is a different story, because the reality is kind of different from sort of, you know, what we would like to think a lot of the times. So in terms of how you protect those aspects, it's really just contractual, unfortunately. And how long that lasts is dependent on how long you agree to. Generally, there's sort of commentary on what would be considered reasonable around those things, and what the courts have decided when people have tried to enforce them. But, you know, definitely not like a trademark that is a 10-year sort of protection. That's probably unlikely unless it's something really, you know, really so important to a particular business. But, you know, that level of protection is not the same sort of thing that you would get in these types of arrangements. So that's kind of the broad landscape of what it is that we talk about in terms of what you create and what you protect and how you go about protecting it. So all of that is relatively systematic in the way that it actually occurs from a legal perspective. And that's all well and good if everything works out as planned, and if, you know exactly, you know, what it is you're trying to protect or what you're creating on an ongoing basis. But the problems are when you actually have to go and enforce all of this, or try and go and stop someone from actually using something that you've created. And that's probably the more interesting aspect of it. It's also the more difficult and more expensive aspect of it. And it's at this point that I get to hand over to Brigit to talk you through how all of that seemingly boring front end aspect of things will hopefully help you down the track if something does go wrong.
Thanks so much, Chris. So the fantastic part of my segment of the talk is that you get to drink throughout it. So please go ahead, help yourselves. The drinks have been brought down. It's going to be very informal and relaxed because I really don't enjoy public speaking. But I do love IP and I do love litigation, perversely enough, and I like sharing that knowledge. So hopefully that will happen tonight. Look, I've been litigating for 17 years, so I've seen just about everything go down in litigation. And one of the consistent things that I see is that people come to litigation with really broken hopes and dreams and very, very unclear expectations of what the litigation is going to look like. And then they embark on that litigation still without having clear expectations of what it will entail. And it's often a very, very unsatisfying process. So what I'd like to propose is that litigation should be seen really as an effective business strategy. And that's the starting point that one should take before you litigate. Is this going to make sense for my business? Is this going to be an efficient strategy? So obviously, if you have spent and invested a great deal of time and money and infrastructure, and you've built something that has enormous potential, it's heartbreaking to see someone stealing that or exploiting that, or a competitor using that unlawfully. I'm going to help you, A, get a sense of what litigation will look like, and B, put out some of the key questions that I think we should all be asking before we decide, should we litigate, should we not litigate, are there other alternatives, what do we do? So the first question that I would suggest that you ask, actually I think it's the question one should ask for any human behavior, is why am I litigating? So the most common reason would be to protect your brand. Somebody, for example, is selling a far inferior product to yours under a very similar trademark, and customers are getting confused, you're losing customers, your brand's getting diluted and damaged. That's one of the reasons. Another reason that people often litigate is because they want to set a precedent. So even if they're just starting out and they've hit a winning product, you see it now with all of those, what are those bags made of? You know, those new perforated bags that have come out? Neoprene bags. So, I mean, suddenly there's this amazing product that's come on the market and suddenly there's just tens of competing products. You have to make a big decision at that point, and that is, okay, I'm a small business, I'm starting out. Do I think big and set the precedent now to make sure that I protect my brand? Because if you don't, you just get lost in the fray. Some people do it to protect the strength of their brand and prevent dilution. Ironically, sometimes you have to do it to prevent your brand from becoming too well known, because there's a strange idea in our trademark law that if your brand becomes so well known that it's generic, for example, pass me the Kleenex or let's hoover the house, then it can actually, you can lose its trademark status. Another motivation is to make money, and that is not an invalid motivation at all. Litigation is not generally lucrative, but if somebody has stolen your song and they've, you know, hit 8 million records and you haven't seen a cent of it, I think it's pretty valid to want to be remunerated for that. And then obviously there are some much more strategic reasons. So for example, I know where I come from in South Africa, there were two particular fish manufacturers that were they just spent years in litigation against each other, and they did it as a strategic decision. So if one bought out a product, the other would bring out a very similar looking competing product, knowing that they would lose the litigation, but during that time they would gain significant market share, and that would be enough for them. So the first thing is you ask yourself, why are you litigating? The second question that I would suggest you ask, who are you litigating against? And then I think you need to measure that up against the reasons for why you're litigating and see if they match. So for example, you're going to ask yourself, am I suing a company or a person? Do they have substantial funds is a question you'll want to know. It has two implications. If they have enormous unlimited amounts of funds, they can litigate for years and years and years and essentially just out-litigate you even with the worst case. On the positive front, if they're a reasonable company, they settle, they'll definitely have the funds to settle a judgment debt. Another example would be for, let's say that the reason why you're litigating is you want to obtain visibility in the market. And the person that's stolen your work is Australia's most loved charity. So you've got to match the why with the who as a starting point and make some calculated decisions, taking into account who the party is that's infringing your rights. Please, as I go along, if you've got any questions, go ahead. The next question that you're obviously going to ask is, what sort of remedies are available to me? If I go to court and I spend this, what am I hoping to achieve? The principal form of relief in intellectual property actions is for an injunction. I don't know if everybody knows what that is, but really it's a court order that stops the infringing party from carrying on doing what they're doing. Alternatively, it prevents them from doing what they're threatening to do in the future. And generally what we'll do in urgent intellectual property infringement cases is we'll apply for what's called an urgent interlocutory injunction. What that really means is we go to the court on a very urgent basis, sometimes within a matter of days, sometimes within a matter of weeks, and we say there's a number of complex areas of dispute here that need to be decided. We understand we're only going to get to court in a year or 2 years' time. We need some immediate urgent protection because our business is being destroyed. And what the courts will do is, taking into account various factors, they'll decide if they're prepared to grant an intermediate injunction, which says until this court is finally decided, party X may no longer continue to use the disputed trademark. What I want to draw your attention to, and this is just a practical thing to bear in mind, is that our courts are very well managed and they are very reluctant to have someone rushing in there and saying, we want a judge allocated to us by tomorrow, we want a court to read all the papers and give us a decision by Friday, but we've been waiting around for 6 weeks deciding what to do. Courts will just throw you out. So if you want interim interlocutory relief. You need to act quickly. Another thing to remember with injunctions is that our courts in Australia in particular, they require you to make genuine attempts to settle a matter, no matter what the person's done. You've got to try and settle the matter before you approach the courts for relief. So what that can look like is just sending out a standard cease and desist letter, giving them a certain period within which to pay. The trend amongst Australian lawyers, because of the trends in the court, is that we've stopped writing those incredibly aggressive letters that say, we're going to blow up your house and then the village and then the entire city if you don't comply. Generally, lawyers will now write and say, these are our clients' rights, this is what we're entitled to do, but we'd like to resolve this commercially. So we invite you to participate in that process. And you'll know very early on whether that's something that's going to be viable. It often isn't, unfortunately. Apart from an injunction, you can get damages. That will be the second most popular form of relief. So damages are often very difficult to quantify because if someone's stolen your intellectual property, your idea, let's say somebody stole your invention before you'd managed to get it onto the market and long before you were ready to get it onto the market, how would you establish for the court that you've actually suffered financial losses as a result of that theft? So damages are difficult to quantify. Fortunately, our courts have, our legislature has created an alternative, which is an account of the other party's profits, which is always great when they've made a huge success of your product and you haven't been able to. So you can choose between damages, and as I say, you'd have to establish what your actual financial losses were, directly linked to that infringement. Alternatively, you can ask for an account of the other side's ill-gotten gains, so to speak. One other thing, our courts in various kinds of intellectual property infringement, like copyright, trademark, patent, they have now introduced additional damages, and what that allows for is that you can ask for a sort of punitive amount where the infringing party has behaved particularly badly. So, for example, someone accidentally takes an image, they didn't know that it was yours, they used it. As soon as they found out that it, it wasn't a free image, let's say, they put it down from their site and they apologized. The court's not going to grant additional damages against them. Somebody that says, that lies and obfuscates and says we didn't use it and carries on using it, our courts are actually becoming more and more generous with the amounts that they award. And in fact, in a fairly recent case, the party was able to prove that they had suffered $34,000 in financial losses. So, and the court then awarded $400,000 in additional punitive damages. So that was quite an interesting case. There needn't be an exact relationship between the amount of your losses and the punitive damages. And then the last aspect that I wanted to discuss briefly is, and in relation to what relief you can get, is the legal costs that you're entitled to, because a lot of people understand the principle that if you win a lawsuit, you're entitled to claim your legal fees from the unsuccessful party. What I just want to emphasize is that the normal order is that a party pays the successful party's costs on what is called the normal scale, and that only equates to about 65 to 80% of your costs. There are circumstances where, again, so this is more specifically where the parties behave badly in the actual litigation, where they've drawn things out unnecessarily. The court will grant indemnity costs, and that'll be much closer to the 100% of your fees. But I think the reason why that's important is that you need to understand that you never come out of litigation like an insurance policy. What you put in is what you get out. Even if you're successful, you're going to be out of pocket, and sometimes by a substantial amount in terms of the legal fees. The next question, which is actually for some people, the first question is, how strong is my case? And what I wanted to emphasize in this regard, knowing from practice, is that we often get clients that come to us, they're extremely upset, they're very anxious, they want us to take action by 2 o'clock that day. And what we advise is that really brief your solicitors fully and comprehensively, get a sense of the strength of your case before you go charging off into litigation. It's very difficult to say to you, you know, you've got a 65% chance of winning at any stage, because litigation is inherently unpredictable. But what often happens is that you're 3 years down the track of a really excellent case when your client suddenly produces a document that completely changes the playing field and essentially destroys their chances of success. So my advice is ask yourself, how strong is my case, and get proper advice in that regard before you proceed. The next thing is, what will it cost? And this is a very difficult question to answer, to be honest, because litigation ranges from $50,000 to millions of dollars in legal fees, depending on a whole range of factors: how complex the case is, and what the level of opposition is. Has the other side got 3 senior counsel, 4 juniors, and a team of 8, and you've just got 1 associate? You have to sort of match their team. So legal fees, I can tell you, just as a sort of, just to cough in the federal court, which is to file the summons, you pay $3,745. And I've never seen a case that has cost less than $100,000, and that is fairly cheap. I'm inspired by those standards. So this is obviously something you want to think about very, very carefully, and why you need to ascertain whether this is a good business strategy for you. Other thing that I want to say is people underestimate the other costs of litigation, the stress, the enormous emotional drain it is. It's very confrontational. It's time consuming. You have key managers that are out of the office for days and days giving evidence, being cross-examined. It's a massive, massive commitment on every level, commercially, emotionally, financially. And as I say, why I'm of the view that it needs to make sense as a business strategy. And then lastly, what I want to talk about, the exciting part, what are the alternatives? So I should actually say I am a fan of litigation. I should have mentioned that. I am a litigator. But when it makes sense as a business strategy, I'm a fan of litigation. But we always want to explore the alternatives, and we always do explore the alternatives. The sad reality is that some of these alternatives that I'll discuss with you, like mediation, very often there's got to be some posturing that takes place between parties. God knows why, but there's the standard posturing that must take place before we can all agree to mediation. So these are the alternatives, but often they sometimes work in conjunction with litigation. The first is mediation. I don't know if anybody needs an explanation of what that is, but really mediation for me is the ideal approach to resolving a dispute. You've got an independent third party that can look at creative outcomes. He can look at issues that go beyond the legal aspects of the case, and he is trained to find win-win solutions. It's also, costs a fraction of the price of litigation. You essentially need a day or 2 to prepare for the mediation, and then the day to attend the mediation. So you're looking at 3 days fees as opposed to 2 years drawn out of solicitors and barristers and etc. And it's become very popular in Australia. So I don't know if any of you have had experience in Australian courts, but really now it's par for the course that any litigation that comes before an Australian judicial officer, they will want you to go to mediation. And they'll very strongly suggest that that's what they want. The next alternative is arbitration. So arbitration is not cheaper. I think there's a fallacy that arbitration is cheaper than litigation. It isn't. But it does make sense as an alternative in certain cases, for example, where the parties are in different countries and the dispute may be around a number of registered or protected intellectual property in a number of countries. So arbitration is the one forum where you can reach a binding agreement that will govern all of those different countries. Arbitration also allows you to choose a very, very specialized, skilled adjudicator. So for things like patents, for example, you really want somebody that knows and understands them. So the parties would be at liberty to choose, a really top patent silk to adjudicate the matter, and that's why I like it. The next alternative is customs complaints. Has anybody ever made a complaint with customs about counterfeit goods coming through? So if this works, this is really, really a great strategy because it allows you to very cost effectively keep things off the market and get them off the market as quickly as possible. Basically, you've got to file a notice of objection with the customs officials, and that notice allows the Australian Border Force to seize the imported goods that infringe either trademarks, copyright, patents, etc. They will then hold on to those goods. The owner of the goods has 10 days to apply for their release, and if the owner does apply for their release, then you have 10 days to issue legal proceedings. But in practice, the owner, who might be, some crook from some far-off island, nothing against the islands, but he may just not want to alert himself to the authorities, and that might be the end of it. Another option, which again I'm in favor of, is commercial negotiations. Take the sort of principle out of it. I don't want to pay for something that I thought of first. Some people just think, look, it's going to cost me X to litigate. This guy's willing to sell this trademark to me for Y. Makes sense for me to buy it from Y. The same thing with domain names. People feel uncomfortable about bargaining with domain squatters. That's a choice. You can decide that you might want to just buy the domain name from the squatter. And then lastly, also in respect of domain names, is filing a complaint under the UDRP or AUDRP. This is an alternative dispute resolution mechanism. It's very, very straightforward and simple to follow through ICANN. For the .com names, you've got to establish a number of things and file a complaint. The filing fees are, I think, $1,500 US, so significantly less than a court case, resolved within a couple of months. I suggest you do use lawyers, although many people don't, but the result is limited to getting transfer of the domain name. You can't get damages, you can't get legal costs. So those are the limitations. And actually, I think, then there was one other one. Another one that I think is very good and underutilized is that all of the sort of marketplaces, social media, Google, Facebook, Amazon, they all have detailed takedown procedures. So if somebody's infringing your copyright, trademark, etc., in a way that you can patently establish, then use the takedown procedures that are provided for on those platforms. And very often it works. And that's really all I've got. Should we move to questions? Are we going to have a...
So that's kind of the framework and the boring aspect of it all. So now it's more, to you guys to say, to ask us questions specifically around what it is that you are concerned about, or particular questions around the IP that you're trying to protect or create. And we can go. So that
Sorry, can you come outside?
Go for it.
Look, the question I want to ask is that we didn't really cover defaming a product. Do you know libel?
I do cover defamation, but it's not considered as part of intellectual property. But I can try and answer your question if you'd like. It's possible to defame a business. I call it defame. It's impossible to defame a business because a business doesn't have feelings. But you can commit what's called injurious falsehoods, which is a similar concept to defamation, but with businesses. Does that answer your question? Okay.
Our question in relation to moral rights. So you think about moral rights. I've heard of moral rights. I don't exactly know what it is. And I'm just trying to understand whether moral rights can be given away to an employer as whether moral rights can be given away to an employer as an employee through their employment contract when the employee first joined the company.
Okay.
And whether I guess that particular clause can be removed in an employment contract.
Okay. So your moral rights are those rights that arise automatically in the creator of the work, who, as you may or may not know, is not necessarily the owner of the work. I think Chris explained that briefly. But the moral rights are the rights of the author A to have themselves attributed as the author. I say author, but it could be the painter, the creator. You've got the right to be attributed as the creator of that work. You've got a right against false attribution, in other words, to have your work attributed to someone else. And you've got a right, a moral right, against that work being distorted. And those three rights you cannot transfer. You can't transfer them to your employee. You can't assign them. The moral rights are non-assignable, unlike the copyright. So what you can do, and what often people do, is they consent to the work being displayed, for example, without the author's name being displayed. Does that make sense? So it's not exactly a waiver, because you can't waive your rights, but you can consent to the work being used in a certain way. I know Alex dealt with something very similar to this recently. Do you have anything to add to that?
No, not really. I mean, it's just about giving that consent. Otherwise, yes, you can't put it in a contract that it's just waived, and it's not waived in general. It's consent for that particular purpose.
Yes.
You know, contracts, as in printed contracts.
Printed contracts. Do they, you know, how you now email something? How much does that weigh if you email like an actual contract? And you email someone, this is my contract, can you email back and say, I agree? Or what does a signature
So do you mean
mean
just
nowadays?
sort of negotiating back and forth via email?
No, it's an actual contract,
Yeah.
but instead of printing it and sending it back and forth, like what does an actual signature mean nowadays?
Yeah. So contracts, a lot of the, depending on the law firm that you're dealing with, if you're dealing with a law firm, a lot of these agreements will have something in there that says that, you know, you can sign in counterpart, which means that, you know, I'll sign it and then I'll give you my signed page and document, and then you sign it, and then those two versions together make one agreement. Or, you know, it might account for the possibility of an e-signature, or it might account for a click wrap. So like, you know, nowadays all the time, like when you go on a website, iTunes, whatever, you click the button, you read, if you read those like 90 pages of terms and conditions, you click that, and that's considered an agreement, right? So generally speaking, it'll usually have something in the agreement that deals with that and says, you know, this is considered to be an agreement in these certain circumstances, or if this is an effective execution on these certain circumstances. But also it's going to be dependent on jurisdiction, right? Because if it is a back and forth of an email, say, for instance, you can potentially argue, if you were to go to court, that that is in itself an agreement as well, because whilst it's not one document, there's a negotiation of terms and then there's performance afterwards, right? So even if you don't sign that agreement, but you guys enter into an arrangement where you're buying a product from them on an ongoing basis, and then for some reason it doesn't work out, and then you want to argue, or the other party wants to argue, well, this agreement doesn't apply because only one person signed it, the response to that is, well, you still performed for 3 years. You still paid that person. They gave you a product. So, yeah, while there isn't a signature there, it's still enforceable, potentially.
It's more like if you have taken a photo and I print your photo in my book and I say, hey, can I print it on email? Can I put it in a book? You're like, yeah, I'm super happy. And I'm like, here's an agreement. Can you sign it? Or can you just write back, yeah, I agree to this? And with your email address, you have written back, yeah, I agree to this.
Yeah, I mean, it really do. Yeah, it's exactly that. So it might not have to be in the agreement itself. And again, it's dependent on what actually happens on a practical perspective as well.
Yeah, so the thing is more, does a signature, like how much does a signature mean in this today's world?
Well,
an actual signature, because I've heard this thing, you know, you can write a thing in a napkin and it's like you sign it and it's legal, but like what actually means something?
it also depends on, you know, when you say what does it mean, who is reading into the meaning.
So if I used your photo and you
Yeah.
said, yeah, you can use it, and then you go, oh, fuck, I can get money of this or whatever. Oh, sorry. Excuse my language. So you go and sue me. You go to LegalVision and you say, oh, she did this. So you're the lawyer of yourself.
No. But what I'm saying is, in relation to a situation like that, in order to get the answer, you're going to have to go to a court.
Okay.
Unfortunately,
Whew.
in those situations. So, you know, we can talk about general contractual formation and what is, you know, considered to be a formal contract. But in the courts these days, even if there isn't two signatures on a page, that doesn't necessarily mean that you can't enforce the terms that were agreed to, however they were agreed.
So it's pretty much up to the judge's mood at the day.
Well, you tell me, you got to call more than I do. What do you think?
I think with what Chris is saying is absolutely 100% true. Is this on?
Yeah.
But in your circumstances, I don't think a signature is, I think there is a signature. You know, when you've signed off an email, Glynis or whatever, that's you signing. There's an agreement. You've offered something, they've accepted it, it's been communicated very clearly. I think the cases that end up before the courts are whether there's a lack of clarity about consent. So it is not really an argument about the form of the signature when it's very clear the parties have signed and agreed to it. Okay. It's more that there's a lack of evidence of there having been that agreement. And a signature can be an email sign-off. If that's the answer, if that's your...
That's the answer. Thank you.
Yes.
Oh, see.
Okay, so are you... Okay, well, let's just talk about it in general terms. One of the ways that in practice people do protect their invention without getting a patent is through trade secrets. So we roll out this example all the time, but it is a very good example, is that the Coca-Cola recipe is still a trade secret. Nobody knows the Coca-Cola recipe, whereas had they decided all those years ago to patent it, then everybody would know it now. The patent would be expired and everybody would be competing with them. So they made a strategic decision. The other way you can do it is to be the best in the business and make sure that you stay ahead of the market. Yeah. Sorry, that lady at the back, I think, has been...
Okay, so my background, I'm a photographer, and I had a question with, like, do I need to go to a certain or any legal firm, I guess, to have, like, standing with, like, a contract? Like, let's say another photographer has their contract and they gave, well, actually, not, let's say it, this happened. Another photographer gave me her contract and said, you can use that with your clients, but just change around, you know, like your name and the dates and things like that. If I did that, does that have, like, legal standing if I haven't gone through someone else? And then also for, like, website stuff and my images online, I haven't exactly gone to a firm. I just, you know, at the bottom right said copyright 2018, blah, blah, blah. Do those two things have actual standing?
Okay, so the first question, whether you're entitled to just cobble together some terms and conditions using a friend's terms and conditions without any solicitor, is legally absolutely fine, but really I can't tell you how strongly I suggest you don't do that.
Yeah.
Because I would assume that you are going to become the world's most celebrated and famous photographer.
Thank you.
Thank you. And then we're going to, when the shit hits the fan, excuse me, we're going to go back and look at that really crappy document that you borrowed from a few of your friends, and that's going to be what you have to protect your rights. So if the short answer is, if somebody says you can use my terms and conditions, they're giving you a license to use their copyright work, yes, you can do it. From a commercial perspective, I strongly, strongly suggest that you don't. Invest in yourself as if you are going to be famous.
Okay.
And then the second question was whether you...
Yeah, the copyright on my website from my
Yes,
images.
so no, you don't need to go to solicitors. You don't even need to say copyright, but you should say copyright next to all the images because, well, for a number of reasons. One of them is that if someone takes your work, they can't argue that they didn't know the images were copyright protected. So put that up. You don't need to go to a solicitor to advise you on that. Your rights are automatic. What I would suggest you do, and not being a creative, I can't tell you exactly what this would entail, but in all your creative endeavors, keep a record of how you came to create that piece.
Okay.
So that if there's ever a dispute about whose is the original work, you're able to prove your claim that this is your original piece.
Okay. Thank you.
Sure.
I've got a question about collaboration with something like an invention or a patent. So, because it gets very messy very quickly. You might have invented X. More than likely, if it's of any value, you're going to end up developing it with possibly a customer or something like that. And there's a time at which the customer turns around and says, well, actually, we contributed to this as well. Now, some of it's about being the user, but it often does go beyond that. Is that a contractual thing or is it a patent thing that we should be looking at that stage?
It depends.
Yeah, I thought it might be.
It's a very lawyer. I got in trouble today from Brigit for saying that. It's a very lawyer answer. Yes and no. It depends on the situation. So, what type of business are we, or what type of situation is this? Like, give me an example.
We've invented a new way of sticking containers on a container ship.
Right.
We're going to be working with the world's largest shipping company.
Right.
They're big, ugly, and very nasty.
Yeah.
But we have to work with them to get the thing proved
get it
out.
done. Yeah.
Chances are we're going to get a point where they're going to say, well, we've also contributed to this thing.
Yeah.
The answer is probably going to be equity, but we're looking at how do we protect ourselves up front, or what should we contract with them to do.
So there's a few things to think about in that situation, and the one thing that you've identified, probably inadvertently, but I would say is probably one of the most important things, is bargaining position. So a lot of how these deals get structured are going to be dependent on the parties that are, dealing with this particular transaction and who drafts the document. So if you're dealing with a large organization, a big shipping company, and they probably enter into these sorts of agreements or arrangements for a number of different reasons, it's a fair assumption that they probably have something in place, or they have in-house documentation that they like to use. That usually is delivered to the other party in a way that is suggested to be, well, we've got it here, it's easy. And that's probably correct. Or we'll foot the bill for drafting the document, you just get your lawyers to review it and whatever. That is partially true. One of the other reasons why is because you can pretty much bet that document is going to secure their rights primarily before it secures anyone else's. So the way that those types of situations work in a practical situation, in a practical example, is that if you're doing a collaboration and, I'm trying to think of a good example, employee-employer, right? You employ someone to develop certain intellectual property, and that agreement from the employer is probably going to say something along the lines of, when you develop something, we automatically own it. You assign it to us automatically. Or if you improve on a process, or you improve on something that we're already doing, or you come to us with a methodology and we utilize it and we find that there's this hack, we generally, as an employer, if you come up with some sort of solution, we will get the benefit of that. That gets automatically assigned to us as well. So it's partially contractual. If there's a patent arrangement in there as well, where you've come up with that, then that will also be dealt with in a contract in some form of license arrangement. But then improvements around IP, it starts to get a bit grey, because it's like, well, who did the work, who owns it, what does the agreement say? And then again, if it does come to a dispute, the question is, do we take it to court, or can we arrange for some sort of commercial resolution outside of that? But generally speaking, it's probably going to be in the agreement.
Thanks.
Hello. Could you quickly cover fair dealing and fair use, and like the possibility of introducing fair use into Australia?
No, is the short answer to that. Unless you wanted to, no.
No one wants to talk about fair dealing.
No, well, no.
It's very academic.
And we've had, well, I mean, what have we been dealing with? Relatively recently, we've had similar questions come up, and the idea of, is it going to be dealt with in a similar way? Are you talking in terms of like the US, or is it going to be dealt with in a similar way? I think this argument's been going on for a while now, but I don't really know what the answer will be, or whether or not that is something that is likely to occur.
More work.
Oh, yeah, you're right. Yeah, it's cool. Yeah.
Thank you. Hi, I just had a question going back to contracts and either drafting your own or coming up with one from someone you know. What, along with seeing a solicitor, is kind of the best way to do that? And are there any resources that you can suggest, or places where you can go to find that kind of help?
Can you just repeat the first part of that? I just missed the first part.
Sorry, in terms of drafting contracts and writing up agreements and things like that.
And so where would you go to get help with that?
Yeah, along with seeing a solicitor. Is there anywhere else?
Sorry.
Yes.
Like a little less, because you have to do like new ones all the time.
Yes.
Yeah.
Yes. Yes.
Depending on the client.
Yeah.
Do you know any resources where an answer, or what are some of the resources that you can get help?
Generally, well, I find that a lot of the stuff that you get for free is kind of crap, to be honest. Unfortunately, in those types of situations. What's the agreement, or what type of agreement is it?
Specifically, thank you. I've just kind of started up a little organization as a sole trader and would be working with actors and working based on MEAA equity guidelines, but then needing to come up with my own contracts with actors and with writers around IP and things like that. Absolutely, yeah. And it's kind of a lot, and I would like to be able to know a little bit about it along with seeing a solicitor.
So my view on this is that, generally speaking, if you're dealing with, say, actors or anything in terms of entertainment, the resources seem to be a bit better when you go and look at sort of the unions and all of that, because they tend to give you kind of templates on how to deal with stuff, especially when it comes. Sorry?
They're not actually legal, which is the tough part.
Right. What do you mean? They're not enforceable, or?
No. So MEAA have a lot of really fantastic guidelines, but they've actually said to us that none of them are legally binding documents, so we can use them in a contract, but we can refer to them, but we can't say these are the legal documents.
Right. So it's really just guidelines that they're providing. And stuff like that.
Yeah.
I mean, a lot of those organizations are also unlikely to provide you with an actual agreement that you could use to reproduce for what you need. And that's namely, I would say that's probably because of liability issues around if you use it and something goes wrong and then you get sued. So short answer is see a lawyer. If I wanted to be, I'm trying to think of a way to say this without saying it. If you happen to see these agreements in practice to give you an idea of how things would be structured, that's also helpful. Definitely not advisable.
Okay.
But a lot of it's going to be around if you're dealing with actors specifically, there's a very specific way of drafting those types of agreements, and a lot of the time the talent agreements are really developed and negotiated with the talent agents and agencies and all of that, right? In fact, law firms tend to not really get involved all that much, because the in-house lawyers in those organizations deal with like the production companies on an ongoing basis, and the actors and all of that, the casting directors and the networks and all of that, and they have a particular way of doing things. So that's one aspect of it, right? But unfortunately, when it comes to producing a document that is secure for you to protect you and your interests, seeing a lawyer realistically is the best way of making sure that, well, really the only way of making sure that your interests are protected.
Yeah.
When you start to cobble together agreements that you find around, legally speaking, as Brigit said, you know, there may be an agreement, but does that agreement do what it should do for you?
Yeah, yeah.
And that's the difficulty.
Okay, thank you.
This is actually a question, right, but it may sound like a statement. In regards to websites, really the copyrights at the bottom that protects, that you may have written on there, the copyrights of images and content, blah, blah, really that means jack, because people can just, because people do copy and mimic everything you do anyway, so you really can't, what's like, yeah.
I'll tell you the point. You're totally right. It offers you no actual protection. It's not like a force field that stops people from stealing your work. But in Australia, you aren't entitled to damages for copyright infringement if it's innocent infringement. So the way I see it is ensuring that if someone does steal the work, you can get damages from them, because they can't say they didn't know that the work was not copyright owned by someone. So that really is the purpose. It's not to prevent someone from taking your work. You're right.
And to enforce it, it would just be so costly, it's not worth it.
Well, this is why I say you can't say that. You need to examine it very carefully like you would any other business decision, looking at the ups, the downs, and make a proper decision as a business strategy, whether it's worth it or not. So if someone's taken a photograph and used it on page 106 of their website that's got 3 users, probably not worth it. But if they've used one of your images in a massive international TV ad, which happens, then it may be worth it. You'd have to examine that quite carefully.
But does the same apply as far as content writing?
Yes.
Even though they might slightly paraphrase it differently, but generally it's...
Well, the issue is not of reproducing it exactly, it's of copying it substantively. So our courts are alive to the fact you can't just tweak something slightly and pretend it's, you know, it was a duck, but now you've tweaked it slightly and it's a pig. Our courts are trained in determining that it's still a duck with tweaking. So...
Okay. Well... Hey?
I probably missed it in today's forum. But if you have staff that are programming for you, so the ownership of the design of the software, if you have employment contract written by LegalVision, does that mean, is there a situation where they can turn around and say, no, I created this so I can walk away with it? They can?
So the example I use, and I'm not an employment lawyer, and so this would be dealt with in an employment agreement. The example I use for this is Google, right? So Google has generally, I think they still do, a deal where if you work for Google, you have like X amount of hours a month where you can work on your own projects and come up with these new ideas or whatever. So the question is, if you come up, if you're at Google, working at Google, and you come up with a new Google, who owns it? Is it that, and you did it on the time that you got as part of your employment arrangement to go and work on free ideas, like you come and develop whatever you want, it's not part of your job, you know, who owns that information? In those situations, even in those situations, I would venture like a pretty good bet that that agreement would deal with that particular item or piece of information being owned by your employer. So generally speaking, the employment agreement should deal with anything that your employees are producing in terms of dev should be owned by the company.
Yeah.
Automatically assigned to the company.
Okay.
Situations where it might be a little bit hairier is if they're a contractor and not an employee. And, you know, the argument realistically will probably come up after their employment ends. If they get fired or if they leave, and then you discover that, you know, they go and develop a program that's exactly the same to the one that you know, had them working on, then obviously you're not going to find that out until afterwards. And the way that that's kind of dealt with in an agreement is sort of restraint of trade clauses. After you leave, you can't go and work for a competitive business, or you can't take any information with you, etc., etc. Query how valuable that actually is in practice. But again, as we were saying before, like an NDA, for instance, is kind of there as a deterrent. These types of things in agreements are there partly to deter, but also partly to protect. How you enforce it is a slightly different question.
Okay. Isn't there a model, right? That would not be assigned.
With
Copyright.
yeah, with the copyright.
Oh, sorry. So it's moral right only applicable to copyright. Oh, like, or that in that instance, yeah. Okay.
Well, this leads to the quintessential question, however. So you can't sell your moral right?
No.
So if you're collaborating on a script with 100 other people, and so you've got a piece of that idea, and a company has bought you either as an associate under contract, a contractor under a contract, or an employee, how can they be assured that all of the things that you talked about, they won't be litigated against down the track should things go astray under this moral right business?
It's a matter of just framing the contractual provisions appropriately so that they're not waiving their rights, but they're consenting to their work being used in a specific way.
Okay.
That protects the producer or the publisher of the film.
Which then means they give up their moral right for
In
X amount of
essence, for
terms,
specific
conditions.
purpose.
Okay.
Thanks. Sorry, can I just ask a follow-up question on
Sure.
that? So usually when an employee is employed by the employer, there's an employment agreement that's been signed. And usually they have, restraint of trade clauses, et cetera, et cetera. And one of the clauses, it's usually intellectual property. So whatever intellectual property you create during your course of business will belong to the employer. And it says, like, part of the agreement probably has the lines of, you also consent to waive your moral rights. Is that?
You can't waive your moral rights.
Oh, okay.
As I say, you can only consent not to raise that particular moral right in relation to a particular use of that work.
Okay, so if it says to any intellectual property created in the course of your employment, that's for all intellectual property created.
Well, you can't just waive those rights. You can't waive a moral right.
Oh, okay, you have to give consent or
Consent
for a
to
specific use.
yeah, to use.
So that's like the end result is?
Well, not necessarily, because, for example, let's say you're a content syndicator and you are purchasing works from publishers who may have agreements with their writers that the writer consented to not be attributed as the author in respect of that publication. But then when you sell that piece of work, you still have to attribute the author. If she hasn't given a blanket, I waive all rights for every purpose, it's in relation to one specific purpose that they consent to their use being used. For example, they may consent to their film being modified in a certain way that might be considered distorted, and that does amount to a waiver in certain respects, but you can't make that a sort of blanket statement.
Right, okay, thanks.
We might have to stop the questions there, just in the interest of time. But Brigit and Chris will be hanging around if you want to grab a drink and chat and network. Thank you very much